Okay, perfect. Welcome everybody to week 9. Our session is about how to approach settlement. We have our guest speaker today is Mina Dillon. So we're just going to go through our kind of housekeeping again. So our territorial acknowledgements. So I'd just like to take a moment to acknowledge our traditional, ancestral, and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh nations. About AC Friends of the Court, AC is a nonprofit organization. We began in 2011 with our first legal forms workshop, and to this day, most of our clients are 45% are family law cases. So the AC Family Law School would not be possible without our generous contributors, and these are the people that we've thanked each session. Just give these names, go through. And a reminder to everybody that we do not provide legal advice. We only provide legal information. So we're not going to answer any case-specific questions, and just make sure that you don't ask any questions specific for legal advice, only legal information. We are recording the session today, so just a reminder to keep your first name only or initials, and to keep yourself muted and your video off. If you have any questions, just send us an email to our email here. And a reminder to please respect all of our speakers, all of the participants, including in the chats. Okay, today about our speaker, Mina. So she is the managing lawyer at the South Asian Legal Connect of BC. So she has been, sorry, just lost my screen. On top of acting as a managing lawyer for the SALBC, Mina also acts as a lawyer for children through the Society of Children and Youth BC, and is a sessional professor at the University of Fraser Valley. Okay. So our objectives today, we're going to understand, negotiation, settlement offers, mediation, judicial case conferences, and arbitration. Understanding and identify why alternative dispute resolution is important. Understand the purpose of ADR, how to prepare in settlement, and understand the role between an interim settlement and final settlement. And then the benefits. Compromisation is key. So screening for domestic violence and power imbalances. Then we'll have a brief question and answer session at the end. So I'm going to pass the session off to Mina so she can screen share and do the rest of the slides here.
I'm just getting my slides up, so
Perfect.
1 second here. Okay, so I'm hoping everyone can see that.
Yes,
and
we
that
can.
everyone
Thank you.
can hear me. I think we should be good. Okay, perfect. So just getting back to here. So week 9, I understand that all of you that are participating tonight are self-litigants in the process of your family law claims. And I'm hoping that you find today's session useful. My practice as someone who practices in various aspects of family law is always to put forward alternative dispute resolution and talk to clients about mediation and settlement. And there's lots of reasons why I believe in doing that. And I think sometimes when people are going through a separation and divorce, there's, as you probably all know, everyone can be at different places when the process starts. But I think almost every litigant in the courts finds it's out that there are lots of things that happen in the courtrooms that are out of your control. Number one is scheduling. Scheduling trials and appearances takes time. It's also very costly if you're in BC Supreme Court, and there's filing fees. And the other thing is I always talk to my clients about is once you have started an action, that doesn't mean that you now have to go to a trial. Along the way, both inside the court process and outside of the courtroom, there is always opportunities to try and see if you can reach agreements on certain aspects of your claim And maybe if you do need to go to a trial, it should really only be on the things you do not agree on. And so in family law claims, there's usually multiple different claims that parties are making, and sometimes they actually agree on some of them. So it's very important to figure out what you can agree on and what you can't agree on. And one of the big differences between going through a mediation or a settlement process versus going to litigation, which is going to court and having a trial, the big difference here is in mediation, or some sort of dispute resolution process, even a settlement discussion between yourself and maybe the other lawyer, is that you will have some control with the outcome. You'll be able to be involved in the final decision, and have control or have some control over some of the outcome. I always say you're never going to get everything you want. If you think you're going to get 100% of what you want, then you have gotten some wrong advice along the way. And this whole process, whether it's family law, litigation, or any other kind of a civil dispute, there's always, you always win some and you always lose some. And there will be some issues that you're willing to move on, and there will be some issues that are what I say a strong no for you. And that is something that you each need to figure out for yourselves. And we're going to talk a little bit about that as we go through the slides today. So one of the benefits of having a mediation or even discussing settlement directly with the other counsel is you can get a timely result. You can come up with some interim agreements. You can come up with if you have a list of issues that you're doing, you can cross off things that you agree on, and then you can focus on the things that you don't agree on. You definitely have more control over the process, and it does require mutual participation. And when you're going to court, there is you lose a lot of control. You never know what the outcome's going to be. Even if you get to the stage of a trial or you have a chambers hearing, in chambers, you will likely get your decision the same day. But if you do a family law trial, I'm not sure if a lot of you are familiar, but it's really hard to get consistent dates in a row. And so it might be that you have 2 days here, 3 days the next, in a few months, and then the final day months later. And then the judge has to put that all together and come up with a final decision and give you an order. And so it's really, you need to decide for yourselves which option you're choosing. But I always encourage people throughout the entire process to revisit settlement options and whatever that looks like for you. The next slide here, what we're going to do is just talk about all the different settlement options that are available to you in a family law claim. And I'm just going to go through this. This is taken directly out of the article that was provided to you this week as well. So, and you will be getting these slides. So it's something you can refer back to. In a family law claim, there is multiple different points where settlement discussions will take place. And first off is just what I will call informal negotiation. This happens between lawyers and parties outside of the courtroom. It can happen before you set even any dates. And this is where you can perhaps, that you're willing to, hypothetically, you're willing to, what your parenting arrangement's going to be. Both you and the other party, you agree on that. So maybe that's something that can be agreed upon in what we call a consent order or some sort of a written agreement. And or you have an idea, you can make a proposal to the other side. I would always encourage that type of proposal to go in writing. And so that there's written documentation that you've made attempts to try and resolve your claim by using negotiation and settlement. When we're talking about informal negotiations, there's no mediators or arbitrators involved. These are negotiations that happen between you and the other side. And if you've got a lawyer at some point, that lawyer can initiate it. But if you don't, you shouldn't let this intimidate you in any way. This is something that you are able and capable of doing as long as you know what you want and what you're willing to move on. The goal of negotiation really is to come to some sort of mutual agreement. And as I was saying earlier, there's really, I've never really met anyone who's gotten everything they wanted. You have to figure out what you're willing to compromise on and what you're not going to compromise on. Now, if you look at it and you've got 8 issues and you're like, oh, I'm not moving on 7 of these, I think you really have to step back and reflect for yourself. Is that realistic? Is that how the court's going to go? If you've never had any legal advice, I would encourage you to take that list to a lawyer or try and get a 30-minute pro bono session with someone and ask them what the chances of success are for you. Because it's very rare that someone would get 100% of what they want. So that's negotiation. Negotiation between parties. It's very cost effective because it's you initiating it. There's no third party that you're paying. Of course, if you got lawyers involved, there might be some fees that you're paying for the lawyers, but you don't need lawyers to negotiate. If you're a self-rep and the other side is self-represented, you can attempt to sort out the things that you both agree on. Yeah, that you can live with. I'm going to move on to the next part here, which is mediation. Mediation is a process that involves having a third person in the room with you to help the parties engage in discussion, help them to identify their interests and their goals, and try and see if it's possible, as long as it's safe for everyone to be in that room, to reach some sort of resolution or settlement. Mediators are trained professionals that deal with conflict, and they are trained in trying to facilitate conversation that can lead to settlements. Now, I say can lead. There's no guarantees that you're going to go to a mediation and things are going to settle. Mediation it's a great avenue to explore, but it is not something that can be forced on anyone. In order for mediation to work and for it to be effective, both parties have to want to participate. And I always say that to clients because they don't realize you can't force someone into a mediation room. Now, also, before mediation is chosen as an opportunity, every mediator will also screen for domestic violence or gender-based violence, and they will assess if it's actually a safe format for this discussion to take place. If gender-based violence there's issues around that, sometimes some mediators will try and facilitate that and see if it can be done in a safe way. However, if the power imbalance is so huge, then that might not be the right option. Mediators don't make any decisions. I really want to be clear about that. Sometimes I talk to clients and they think, oh, well, the mediator will decide for me. No, the mediator's role is to facilitate discussion. Not all mediators are legally trained. And what I mean by that is there is lots of family law lawyers that do mediation, but there's also other non-lawyers that do mediation. So as you hire a mediator, you need to kind of think for yourself, do you want someone who has a legal background? Or if it doesn't matter to you, then you could select a mediator who perhaps maybe has more experience in dealing with issues that are relevant in your family. And sometimes I have a lot of experience working with children. So, I sometimes am asked to mediate based on my specialty. And so everyone has something they're looking for, so you can explore what kind of mediator you want. The goal of the mediator is to facilitate discussion. You can never be forced into any sort of agreement in a mediation. Though some of you have not been to a mediation, usually you start off in the same room or the same Zoom, because sometimes mediations happen online now. And at some point, when parties are starting to discuss settlement issues, mediators will divide parties into separate rooms to help facilitate a better discussion. And then if agreements are being made, then what they will do is bring you back in the same room. The mediator typically will draft what we call minutes of settlement or a mediation agreement, and then they will give it to you. At no time should you feel pressure to have to sign that in that moment. If you had a lawyer in the mediation with you, that lawyer will explain the agreement to you, and clearly you should know about it because you participated in the mediation, but also just to make sure that you understand what you're signing. If you have participated in a mediation and you were there by yourself, you should feel comfortable asking for time and saying that I want to get some independent legal advice before I sign off on this agreement that I've helped produce. And it is really, don't feel pressure to sign it in the moment, and mediators will be alive to that issue. They also will encourage you to get legal advice before you sign off on it. So that's what a mediation is. Now, the negatives of mediation is it is costly. You do have to pay for your mediator. There aren't two, there's only maybe two places where you can get some sort of mediation. Now, family justice counselors that are usually present in most courthouses do some mediation, but they don't do mediation for asset division or I believe spousal support. There's two areas that they will not mediate. Access Pro Bono BC is an organization, and they have a mediation project where you can apply to see, based on your incomes, if you can qualify. And they do have a roster of mediators that will do your mediation for free as long as you qualify. But so there is an income cutoff there. If you're interested in that, that is with Access Pro Bono BC. And finally, I'm going to launch into in the courtroom settlement processes that take place. Courts have long delays. There is a backlog, and it's taking even longer to set down trial dates. All throughout the family law litigation process, at various avenues, there are conferences or settlement conferences that can take place. Some of them are mandatory. Some of them can be set up or conducted at request. Now, a trial management, actually, I want to talk about a family justice conference or family conference that takes place in Supreme Court. That is pretty routine that happens. You'll be in a room with a judge. No decisions can be made there unless there's an agreement, but the judge will try and facilitate and figure out what the differences are and if there's any similarities, and try and encourage some sort of resolution. But once again, at a family conference or judicial case conference, the judge can't make orders around, parenting time and things like that unless there's a consent. Trial management conference is something that happens right before your trial. It typically has to be set, don't quote me, but at least minimum 28 days before your trial, might be even sooner. But this is a conference you're going to have in front of your judge before your trial date, and the judge will want to make sure that there's an agreement on your records. Are we still going to trial on the same issues? Is there enough time that has been allotted for the trial? Are there any outstanding issues with respect to process that need to be looked at? And so that will happen at a trial management conference. There is orders that the judge can make at a trial management conference that have to do with process. And you can look at the BC Family Supreme Court rules to figure out what those orders are that a judge can make there. Now, inside the courtroom, if there, for example, is a chambers application, there is opportunities to ask the court if there can be an opportunity to go, have a settlement conference with a judge. You can apply for that. Also, if you're the only people in the courtroom, there are some times that I've seen, especially when there's self-representatives in the room, and for example, there's a chambers application, the judge will really try and facilitate and make sure that the self-representatives really understand what's going on and understand what's at stake. And, for example, if it's an issue that likely should resolve, the judge, will point out the cost and the time that it will take to get it resolved through an actual hearing. And so these are three different options that are available to you. Now, I want to say that there's no deadline on these, right? So there's no deadline on negotiation and a mediation. It doesn't mean you have to have it right at the beginning. I would always say that you should constantly reassess your case to see if there's anything that can be resolved by way of settlement. And maybe you tried a mediation in the beginning and it didn't work. Well, now maybe a year and a half has passed and people are in a different place. If you want to give it another shot, it's worth asking the other side. But once again, remember that with mediation, you can't force anyone to participate. They have to be in the right place I always say both parties have to be in the right place for it to be successful. Negotiation can keep happening. Informal negotiation outside of the courtroom can happen throughout your case, and it is something that you should revisit constantly. So I will just go to the next slide here. So when you're thinking about your case and you're thinking about um, settlement, there are some positive ideas or attitudes that encourage you to consider as you approach your case. So one of the first ones right here is I talk to a lot of clients who think that they're going to look weak if they propose a settlement or if they make some sort of proposal to the other side. And sometimes I meet clients that say, well, no, the other side has this really tough lawyer and they're super aggressive. And, you know, when you're talking about like your case, this is your family law case. At the end of the day, it's going to be your money and your time that is spent trying to resolve this. If you are in a position to make a proposal, don't consider that as a sign of weakness or you not being as aggressive as the other side. I think that it shows a lot of when you can step back and look at things that maybe you can agree on and you propose that to the other side. I think it's a positive. It can help move things forward for you and sometimes offer you the finality or the closure that you may need on certain things to move forward on other things. Always keep your eye on the possibility of resolution. This is really like, oh, sorry, sideways. This is really important because, like I was saying, maybe like you tried mediation at one point in the early on, or there was some sort of negotiation and nothing went on, like nothing came out of it. But don't let that be the end of your opportunity to have settlement discussions. When I say keep your eye on the prize, you're always looking, usually when people are going through a separation or a divorce, they want to move on with their lives and they want to usually get things done. So that is the end to this process that you started. And if you can get to this end by way of resolution, well, why not? Why not consider that? The other thing is not everything that comes before you should be something that this should be a battle for you. You really need to think about where you want to focus your energy and where you want to focus your money if you're spending money going to court and doing all of this. If someone, I always use this example. I once worked on a family law file where the parties probably easily spent close to $5,000 over, it was flower pots that they were not able to reach an agreement on how to divide them. And, those flower pots weren't actually worth that much money. And so when you don't have someone, if you don't have a lawyer who can guide you in this process, I think that you should always run things by someone in your life who you feel that has some common sense that can step out of this. It's really hard sometimes when the dispute is about you. So if you can, someone you trust that you can talk to them and get their opinion, then you can reassess your position. And you do want them to be neutral. So if you're going to go to someone who's already siding with you, that's not a neutral person. Maybe look for someone who's calm, who doesn't get into a lot of conflict, and get an opinion from them. Continually reassess the possibility of your settlement. As I've been saying throughout here today, never give up on settlement. I would say 90 to 95% of family law cases settle. That's how they resolve. Most cases that are before the courts, I would say, like in other areas of the law, almost 80% go through a process of settlement. So it's one of the biggest ways that you reach a resolution. So always come back to it, always reevaluate it for yourself and see if there's an option there for you. Be pragmatic and be realistic. If you are going into this thinking that you're going to get 100% of everything you want and the other parties, for example, I've talked to clients who say, well, I want to be the only parent. Well, no, your child actually they're entitled to contact with both parents unless there's very good reasons for that not to happen. And so always be realistic about what you're asking for. And I always encourage my clients to think about it from the child's best interest, because that is the test that the court's going to be using. Whatever it is that you're proposing, is it in your child's best interest? And so It's a hard thing sometimes to do, but that's what I encourage you to do. If you are self-represented, which a lot of you are, and there's counsel on the other side, don't fear that person. I think that's someone you can actually probably um have some off the record conversations about that, I can share with you. When there's two lawyers on the side, they typically will kind of like indirectly scope out the other party's willingness to come to settle. And I think that you should also, as self-representatives, keep that door open. And maybe, you can, if you are feeling like you might be able to agree on some things, it's worth it for you to talk to the other lawyer and say, hey, would so and so be willing to reach an agreement on this? And you can just say off the record, I'm curious. And then if they are, then you could perhaps put something more formal to them, or in that moment you could just say like, I'm willing to resolve this way. I'll be open to knowing what your client says about that. And never ever take yourself out of the loop so that you know what's going on. And so if you are self-represented and there's counsel on the other side, you should ask to be, sent emails. You want to be kept in the loop. If there's anyone else involved that you want to know what's going on with your file. If the other side has a lawyer and there's a paralegal, you want to make sure that paralegal knows to email you and to send you things directly, especially if you're self-represented. So stay in the loop, make sure you read your stuff. I sometimes tell clients, because they don't want their, and they also don't want to see emails from like the other lawyer, for example, if that work. What you can do is set up a separate email account and then check it like on a regular basis when you want to see those emails. Reality checks when we're talking about settlements are really, really important. And I know like when you go through your case, it's the most important thing happening for you in that moment and for your kids. But don't assume that your case is unique and it's different. It's, like the court's never seen this before. The courts are full of family law cases, and they all involve division of families and division of children and division of assets. So it's very few things that the courts haven't already seen and that they haven't already dealt with. And the same goes for a lot of family law lawyers and a lot of family law mediators as well. Be realistic about your position and what you're proposing. Don't wrongfully think that a judge is going to side 100% with you. Legal outcomes or the outcome of a trial is, you never know, it could go either way. And there are lots of decisions out there that will be on both sides. And it really comes down to how the case was presented to the court, what was the evidence, and if it's a decision involving children, who was able to prove what was best for the children. And then the judge is the final person that makes that decision. If you have your case and you think it's unique and you're going to win everything, then you need to learn how to use Canly, which is a free website that has cases on there. And you can put in, you can start reading family law cases from the court on there and see if you find one where someone got everything they wanted, like you. On, just from a few cases, you're going to find out very quickly that no one ever gets 100% of what they want. Very rare. There's always compromises, but there is definitely one side that usually gets more of what they want, but it's hard to get everything that you want. Don't express your anger in settlement or legal processes. It's counterproductive. And I want to share an example of that. If you are getting ready to go to a settlement process, what you need to do is a lot of times there can be hurt feelings. These things are emotional, but when you are trying to negotiate a settlement, you have to put some of that aside and focus on the end result. So you may hit, the other party may have done you wrong, and the family law case is not about that. The family law case is about, okay, you were once together with someone and now you're not. So what is that division going to look like? It's not about penalizing or taking revenge against the other person. Also, if you have some undealt with feelings, or you rightfully may have anger towards the other side, that is something that I encourage you to deal with through counseling. And it is not something that you should be bringing up during settlement discussions. It will slow down the settlement discussions, because the idea in settlement discussions or negotiation is to focus on the issues, not make attacks or passive aggressive comments to the other side. So I know it's hard, so I just give you that tip for that. Delaying resolution or taking I'll just wait it out approach. I see this a lot too. I've definitely spoken to clients who say, well, I'm not going to give the other side a divorce until they do X. Well, really, once you've been separated for a year, separate and apart for a year, a lot of the grounds for divorce, like the requirements are met. So you can't really force someone to stay married to you. And so be realistic about what it is that what is your end game here? Are you actually planning to move forward, or are you not? And you want to slow this process down, and then think about everyone else who's involved in that process. If you have children, do you really want this to linger along and have an impact on them as well? Step back and always think about the impact on your children. And also the impact on you personally, because these things are very difficult to deal with. They can cause a lot of stress and a lot of financial and emotional stress. And so sometimes delaying a resolution or taking I'm just going to wait this out approach might not be the right approach to take, especially if you are someone who can benefit from having some of these things resolved with, benefit personally for your own personal mental health. And once again, don't assume that you're going to get everything that you want. You should be, I always tell clients, be ready for the worst case scenario and figure out, what is your worst case scenario? What if you went to a trial and you didn't get anything that you wanted? How will you feel? And in that case, if you didn't get everything that you wanted, what were some of the things that you could have lived with? And make that list, and figure that out for yourself. Preparation is really important in family law, period. As you know, there's lots of paperwork, but it's also really, really important for you to figure out what are the issues that need to be dealt with, or issues of dispute. What are the things that are in dispute? So I would write those on a list, and then I would make a second column, and I would make my dream list of everything that I wanted. It might be everything that was that needs to be resolved. How should that be resolved in your dream list if everything went your way? And then you should make a second list of the things that you can live with, things that you're willing to compromise on if it works and is something that you can live with, a resolution perhaps. Now from those two lists, there will be things that you're willing to negotiate on that you're not as strong about having, that you would be willing to perhaps see a different version of what's on your dream list. You should have this list. Some people have it, in their head. I encourage you to go through a process of writing it out if you can. It can be very helpful, especially as along the way, as you reach settlement on different issues, you can go back and say, okay, well, this is what I wanted and this is what I'm getting. So it's a way for you to measure where you're at and ask yourself, really think about living with what it is that you're ending up with. It's also very important, as you're going through this list, to ask yourself, why is something very important to you, and why is it that you're not willing to move away from it? If you don't want to move away from it simply because it's a form of punishment for the other side, then that's likely not a good enough reason. You should, on those types of points where your reasons are perhaps not to file forward, is to really then, the second question is, what is the impact on my children for me delaying this decision, or for me not wanting to move this forward? Is there an impact on my children if you have children? And what is that impact? And maybe that will help you as well. If you go through a formal mediation process, the mediator will always try and also figure out what are your strong points that you're strongly tied to, and what are some of the points that you're willing to move away from. As you're going through, ask yourself, is there someone that you need to speak to before you can make a final decision. Now, for some people, sometimes they need to talk to a friend or a family member. It's really important to know who that is. Especially if you're going to a mediation, you want to be able to tell the mediator that, um, I'll do this mediation, but if we get to an agreement, I need to call my mom, or I need to call my mom all the way through, because they might not be a participant in that mediation, but you could be in a separate room, and have the opportunity to call them. Okay, so that's really important. If you're going to go to a mediation and there's assets involved, or there's any sort of support involved, child support or spousal support, then it would be, not the best use of time if all the documents have not been shared. So you need to provide full financial disclosure to the other side, so in advance, so that there can be an opportunity to deal with all the documents beforehand and have the evidence that is needed, perhaps for the other side, to work out what the numbers are going to be if that's where we're going. So you need to share your documents with the other side, and the other side needs to share documents with you. And then if you are going into mediation, have what plan one, your dream list, and plan B, the things that you're gonna, can live with and that you're flexible on. This may seem really basic and simple, but I can tell you it's a really, really important step. And I encourage you to revisit this, especially if you've been in a process of separation or divorce, like it's gone on for more than a year or two. You should visit this process at least once a year. I found it's really helped a lot of my clients. Now, understanding settlements or orders from the court, there can be what we call interim settlements, and then there can be final settlements. Now, final settlements, the word itself gives it off. It's a final settlement. That means that it is ultimately is permanent, like it can be entered into a court order. And once it's entered into an order, then you need to go through a process of having it changed, perhaps due to a change in your circumstances. That would require an application. But if it's a final settlement, it's done. It's there, and it's binding. Interim settlements are what I don't like. The interim word really means temporary. And these are temporary arrangements that are made until you can get to a place to get a final settlement. Interim settlements are very beneficial, especially in the early stages of separation. They can help make some temporary parenting arrangements. You can make some very temporary arrangements with respect to child support, because there might not be all the financial information that you need, and sometimes even with spousal support. But interim arrangements usually deal with parenting time. They can deal with financial support and also sometimes assets. But a lot of times in my practice, like, people start dealing with assets as time goes on. But most important issue usually at time of separation is, what is the parenting arrangement going to be? And then also child support can be really important. Interim arrangements, which are temporary agreements, they're in place until you have a final agreement. And now it is possible to take your interim agreement and put it into either a mediation agreement or a final consent order and make them final. But unless you've agreed that they're final, they will remain as interim. So be careful of that too, because sometimes I see people, they've made interim arrangements and then they've just gone on their own ways, and then they've never really engaged in the process of having a final order in place. So how do you participate effectively in a mediation? The first thing is, if you're going to be in the room with someone who maybe you don't want to be in the room with, prepare yourself for that. And what I mean by that is, make yourself ready to be in the room with someone you may not like anymore, or that you may have some real feelings of anger towards. And, that's different for everybody. And so if you're going to go through a mediation process, that is probably something really important to talk to the mediator about, and, find a way, let the mediator know that you're willing to, hopefully you're willing to start in the same room, but maybe you're not willing to start in the same room. Most mediators will try and get you to start the process in the same room before they separate you out. But it's really important. So prepare yourself for that. Number one, whatever that is for you. A lot of people do lots of different things. Some people do mindfulness. some meditation and breathing. Other people will, work out or go run before and just, get themselves ready. Um, be ready and even practice explaining why you want something, what is your proposal, and why is it important for you. And when you are doing that, I encourage you, as much as possible, if you're, especially when you're talking about your children, to not use the word I. I want this for my kids. No, I would rephrase that like, this is something I'm proposing for our children because our children, so use an our or a we, so it's more joint or shared. Sometimes I know I've seen people saying, well, I want this for my kids. Well, first of all, they're not just your kids, they're also the other party's children as well. And so you have to be encourage you to be a little mindful of your language and try and use more, if you can, language that, especially when you're referring to children, that you refer to them as our children or, instead of my children. Also, if you are entering a settlement process, whether it's an informal negotiation or you're going to a mediation, you want to be upfront. I'm here with an open mind today. I'm open to settlement. I'm committed to kind of talking through and working through things. However, I want a fair settlement. Obviously I wouldn't encourage you to go into a settlement and then come up with something that you didn't believe in. And so be realistic, be pragmatic, and also and as you enter the mediation, assure the people in the room that you're there with an intent to settle. It's already said the next line there. Avoid describing what you're looking for as demands or entitlements. I can give you an example of that. So don't go into a mediation or a settlement meeting and say, I want this, or I'm not agreeing to anything, or, I need this and I need that. I think it's a better way to explain it is, I'm proposing that this go this way, and this is beneficial for me and the children because, or this is beneficial for our family because. So it's just rephrasing in a different way instead of, if you go into a room and you make demands, it's going to shut off the conversation. And the goal in a settlement process is to have the conversation flow and encourage discussions amongst the parties, because a lot of times, not all, but a lot of the times, there's more similarities than there are differences in the resolutions. And people get, sometimes people get served with the notice of family claim, then they think, oh, great, now I'm just going to be in court. And court's one option. So even if you've been served with the notice of family claim, remember that settlement options are always there and they're always present. So what to do if you reach an agreement? Well, this is going to sound very basic, but you want to make sure the agreement is in writing and that you have a copy of it in writing. Once you have that copy, you need to assess for yourself. But I would encourage you to take it away and ask for some time to review it. Make sure you understand each and every clause in that agreement. If there was a lawyer involved in the process, and a mediator, the agreement generally should be fair, but still you need to read it for yourself. And you are entitled to ask for time. You should ask for time to think about it. I encourage you to sleep on it and think about every term and how it's going to impact you. Is it already in place? Is it working? Is it something new that you've agreed to? How will that look in your life? And then pull out your sheet where you had your plan A and your plan B. What are you compromising on? Have you measured against what you wanted, especially against your wish list? Where have you landed on that? Hopefully you got one or two or three of the things that you wanted, that they went the way you wanted, and it's something that you can live with. If you went to a mediation and you went as a self-representative and there was no lawyer on the other side, and then you didn't have a lawyer, but also, or the other side had a lawyer, they didn't have a lawyer either, then both of you should get independent legal advice before you sign that agreement to make sure that nothing has been missed and that it's truly in your best interest to sign the agreement before you do. Once you agree with all the terms and conditions and you know you can live with the agreement, then you should sign it and you should provide it to either the mediator, to the other side, so they can also sign it. Once you have a signed mediation agreement, you can then use that to put together a consent order and get an order from the court, or you can just have that agreement in place. But I always encourage people to take the mediation agreement and get an order from the court, especially if it's an agreement that you've decided you mutually have agreed that this is a final resolution to your issues that are in your family law claim. So I'm just actually gonna take a break a little bit early here because I know we're at 6:16. Why don't we take a 15-minute break? Rachel, you okay with that?
Yeah, totally. We'll take a
Yeah,
15-minute break and then we'll come back at 6:30 and continue.
30. Yeah, and then
Yeah,
we'll finish it off. And depending on how many questions we have, but I think that we might be ending a little bit early, but we'll
that's
see.
good.
If not, yeah, let's take a break right now and then like come back at 6:30, please.
Awesome. Sounds good. We'll see you then. Okay, so did you want to get started again, Mina?
Yeah,
Okay, perfect.
yeah. So I'm not sure if everyone's back, but we will get started. So I just want to say, I see that there's questions there, and then we'll answer those at the end of the presentation. Um, so just before the break, we're talking about obviously settlement options and what happens if you reach an agreement. And so I had given some tips on the other slide on what to do, and then I will just reinforce that before you sign the agreement. Now, if you go through a mediation process, that involves you being in a room, usually for 3 hours. Sometimes family law mediations can be almost anywhere from 6 to 8 hours. And at the end, you may not have the brain bandwidth um to review that agreement and sign off on it, even though you've been a part of this process the entire day. So you should always ask for time to take it away. You need to assess if the agreement is fair, it's practical, it's something you can live with. Because if you sign it and it's a final agreement, then that says that you're willingly signing it and it becomes a final agreement. As most of you self-representatives, make sure that if you've gone through a mediation process and there's an agreement, that you find a way of getting some independent legal advice on that agreement. And you may have to pay for an hour of someone's time to do that, but it might be worth it if you're entering into a final agreement, to make sure that all of your rights are protected as well. I myself, before I make some sort of final decision, I always like to sleep on it, think things through, wake up. If you need more time, take more time. But by more time, I usually mean like a week, not 2 to 3 months. If you have gone through a mediation process or there's some sort of settlement discussions, and there is a informal an agreement, then it needs to be signed off on. You can take your time, but you make sure like it doesn't go longer than a month. And if it is, then you should provide an update to the other side, explaining that there's a few things that you're still sorting out before you sign it. And that would be the respectful thing to do. But do get some legal advice on the final agreement, if it is something that you're resolving issues in a final way. A lot of times your agreements that you make in a mediation, you can take the contents of that and put it into either a consent divorce order or a consent final order as well. So assessing settlement, considering your best alternatives to a negotiated, settlement. Always consider your best and worst alternative to settlement. You have to be realistic here. This is where you want someone who's perhaps a little bit calmer in your life. Not that you're not calm, but someone that you trust, and someone who is able at resolving things in a calm way. I would encourage you to talk to that person and get some advice about what are your best options and what is the worst case scenario when you look at settlement. A lot of times people tend to get advice from other people that they know that have been through the process. That can be good, but it can also be bad, because everything in the courts depends so much on what was before the court and what the evidence was before the court. And maybe someone will tell you, don't do this, or this is how I ended up, but you may not be getting the full story in that situation. So it's a good idea to see if you can get some advice from someone who's neutral, who's going to look at it from they're going to step back and look at it and help you assess if the settlement is good for you, or if it's something that you can live with, but also help you figure out for yourself what is your best case scenario and what is your worst case scenario. And I also want you to, when you're figuring out your BATNA and your WATNA, which is the abbreviations for best case scenario and worst case scenario, is what happens if you don't sign the settlement? What are the next steps? Usually the next steps are to go to a trial, and that may involve giving evidence, being in hearings for 3, 5, 7, depending on how complicated things are, or how many complexities there are to your issue, can be up to almost, anywhere from 7 to 10 days in a trial that is spread out over a period of time. Then after the judge hears all the evidence, it does not mean that they're going to give you their judgment that day. So you still have to wait for the judge to give you their judgment. So figure out what that time and that cost looks like in your life. And is it worth waiting for that? That is what you need to assess for yourself. You know, and what are the differences? So what is it that you're waiting for? What is it that's in the agreement that's you wished was in the agreement that's not there? What do you think a judge is going to decide on that issue? What will the judge decide on other issues? It is quite possible in your settlement agreement that you got something that you didn't think was going to go your way, but it went your way. Are you willing to risk having that go a different way if there's a trial? So when you're assessing your best case scenario, your best alternative to a negotiated, like a settlement, you're really asking yourself, how likely is it that a judge will agree to give you what you're asking for? How likely are you going to get what's in the settlement agreement versus what you're aiming to get from the court? Um, how long will the decision take? How much money will it cost? Are you willing to put in that time and wait? And if it's going to take a year to 2 years to get a decision, and here you have a settlement that gives you, I'll just use a percentage, gives you 75% of what you were asking for, then you really need to think about, can you live with it? Now, if you've looked at it and you in your head, the agreement is your worst case scenario, well, maybe then you don't. If it's a worst case scenario for you that's been settled, and you've received the legal advice that that's the worst case scenario from you, and someone else has told you that that's credible, then maybe you are going to go to a trial, and maybe that's the way your issues get resolved, right? So it's always, unfortunately, this whole process is always about figuring out what is best and what is worst for you at that particular time, given everything that's going on in your life, and assessing that for yourself. Usually, as a lawyer, I can't tell clients, oh, you should sign this, but what I can say usually is, this is a fair settlement. These are the things you told me you wanted, and this is the stuff that you didn't get. But you need to figure out for yourself, can you actually live for that and have some finality right now? Or do you want this to go on for a little bit longer? Depends on what the issue is and what it means to you personally. So I know I've said this several times today, but like a process of considering going to settlement is ongoing. And just because something didn't go one way in the beginning, it's possible things will change as time passes. People have different viewpoints, things happen in people's lives. Sometimes there might be someone who won't even hear the word mediation when the process starts. But 6 months, a year into the process, guess what? They're in a different place, and they would like to see if you can resolve some of these things. And I always say, like, the things that you don't want to move on, you really need to figure out why you don't want to move on them. Well, what is it about that particular issue that is so important to you that you're not willing to negotiate on it? And you need to ask that for yourself, and be very clear about it. And sometimes if you can explain to the other party why it's important to you and why you won't be negotiating that, um, it will let the other side know, and it will let you know whether or not settlement's even an option for you. And if the issue is so important to you and that the other side's not going to agree to a settlement and you're not willing to move on it, then you have some clarity there that this has to go to a trial, and that judge will be deciding what happens. And then once the judge gives you your order, it's a final order, right? If it's a trial, so it's a final order. And then you can't just appeal it if you don't like it. There has to be an error in law. And that whole process is probably another week that you're going to cover in the course, but it also is an expensive endeavor. And, I always tell my clients, if you don't like the judgment from the court, you can't appeal it just because you don't like it. There has to be a reason for you to appeal it. Usually there has to be an error of law, or, some issue with some of the facts. So always be open to settlement, always kind of consider what is it that you can live with, what is it that you can't live with. If there is a settlement proposal that has been sent to you from the other side, look at the strengths and weaknesses of that for you. Where does it line up? If you receive a settlement proposal, where does that line up with your best case scenario? And where is it lining up with your worst case scenario? settlement is always your decision. And I can't stress that, but although it is something that I strongly recommend, that process that you go through, it is something that has to happen for you at the right time. And even if you go through the process before you sign off on anything, before you agree to anything, it's your decision. And if you need to speak to someone, or a lawyer or someone that you trust, then you should take that opportunity to do that. Now, if you yourself was someone who was not open to settlement when your process started, but now you've changed your mind, there should be nothing stopping you from engaging the other side. I would say in writing, to say, hey, are you willing to discuss settlement with me? Are you willing to negotiate or enter into negotiation discussions on X, Y, and Z? I encourage you to put it into writing and keep that for yourself, because if the matter goes to trial and there's a judgment and the decision from the court is similar to what you proposed in settlement, you might be able to use that if there's arguments around costs and who's going to pay costs in court. Costs are something that the winner in court pays to the other side, and it's usually the winner who wins the most issues, not all the issues. And so as you are engaging in settlement, I would always encourage you to document in paper that you've made efforts to settle with someone, that you've made settlement proposals, date them, keep them. They might be important at the end if the matter goes to trial. Always get legal advice about going to settlement, but also any documents that come out of that process. Don't feel pressured to settle. Again, it's your decision and it's your life. Make your own decisions, even when you're feeling pressure from other people. That can be very intimidating, being in a room, perhaps with the lawyer and the other party on the other side. And if you, as I was saying earlier, if the mediator, you can let the mediator know that you will be in a better place to settle if you're not in the same room as the opposing party. You can always share that with them. And typically most mediators will start you together and then they'll facilitate by having you go into a separate room. Now, before I go into my conclusion, there's one more thing I wanted to talk about, and that is, you may have heard of a process called Med-Arb, which is mediation and arbitration at the same time. Now, that process is very different than what we've talked about here. So it is actually, you hire someone, a mediator, who's also an arbitrator, and you hire them with the intent of, we're going to try and mediate these issues. But if we can't mediate them, then we want you, mediator / arbitrator, to make a decision for us. That is what Med-Arb is, mediation / arbitration. There's very particular people that do that. A lot of people take this route now because they want finality and they want a decision and they don't want to be going to court, incurring the costs of filing affidavits and bringing witnesses and all of that, and then waiting for a judgment from the court. So a pro of mediation arbitration is you still go through a mediation, and if no agreements are reached or if there's issues that were resolved, but some of them have been left in dispute, the arbitrator then can make a decision for you that you have both agreed that the arbitrator is allowed to do, and then their decision becomes binding. So that's what a mediation arbitration is, and it is important. It's becoming more and more popular because as I was talking about earlier, there's definitely sometimes issues that people are not willing to compromise on and they're not willing to move. And those two issues might be the same on both sides. So then definitely a third person has to make that decision, like be the tiebreaker, if we want to say, or the decision maker for sure. And that ends up being the arbitrator. So mediation arbitration, once again, that is a private pay service. And what I mean by that is that you have to pay for the mediator and the arbitrator and bring them on. Both parties have to agree to the process. Both parties have to agree that the mediator will be also an arbitrator. And then usually the agreement will say the determinations from the arbitrator are final and binding if it's being done with that intent. So I'm going to close off my slides here. So with settlements, I want to say that 95% of family law cases resolved by way of settlement discussions or mediation process or mediation arbitration. They're non-family law cases also usually resolved by way of settlement. Dispute resolution, which is the word that we use collectively to describe a lot of these processes that I've talked to you about, is something that is endorsed and supported by the courts. The courts want people to sit down and try and see if they can resolve things together without having, a judge making a decision, especially when it involves children and families. You can never be forced to make or sign an agreement. It has to be your choice. It has to be your decision, especially if it's a settlement process. One of the positives of going through a settlement process or a negotiation is you retain some control in the outcome. Whereas if you enter a courtroom and the judge is going to be making that decision, you don't have a lot of control over that process. It's how the judge interprets. It's all about which judge you're getting, what their experience is, how did your witnesses do in trial, who gave the best evidence, and so you lose a lot of control once you enter the courtroom. As you get a mediation agreement, it is very, very important to, like I said, figure out what this means in real life for you and get very clear on within the agreement itself, what can be taken back to court and what is final. A lot of agreements will talk about going to another mediation if there's a dispute over something. So you really want to be mindful of that in the agreement. What things can go to court? What is the process when a certain part of the agreement has to be reevaluated? What is the process? Is it going to be another mediation, or is it going to be a court, or is it going to be an arbitration? Always put settlement agreements in writing and make sure they're signed off properly. And by that, it's good to have a witness, good to get independent legal advice before you settle. If you have separated and you hired someone to do a one-sided settlement agreement, which I've seen, and the other party just doesn't want to go through the process of divorce and separation, and they sign that agreement without reading it, and it's an unfair agreement, then there's a whole other process that has to happen to turn over an unfair agreement. And if there was no legal advice and no encouragement to legal advice, then the strength of that agreement is not good. So if you are putting forward a settlement proposal or a settlement agreement to the other side, you too want to stress, hey, you should get legal advice before you sign this. And that's because then it makes the agreement more credible, and it allows the other party to also get advice on the agreement before they sign it, and there's either, some sort of final order. Always take time to decide. I know I've said that. I know there's usually a lot of pressure in these situations, and there can be a lot of just feelings of wanting to get things done. But if you need to take time, then please take that time. You're always welcome to get a second opinion as well. So if you've taken the agreement and a lawyer one has told you something and you're not, maybe you just want a second opinion, you want some consistency, you can speak to another lawyer and see what they say as well. And when I say envision yourself living the agreement, I mean, play it out in your head as you, especially if, for example, those shared parenting arrangements where some of them are like 4 days on, 3 days off, like map that out on a calendar for a year and see what that looks like for you with your life. Lay it out, see where the holidays fall, see where the birthdays fall. It's very important to map some of these things out to see how they impact you. Because sometimes people enter these and then they realize, oh no, like all of my days are when, important days in my life are when the kids are with the other party, and how is that going to be dealt with? Then that is an issue that you want to deal with in settlement. And, there's some important days that need to be shared between both parents, or, so make sure those things get documented in your agreement. Yeah, settlement is your decision. So that brings me to the end of these slides. But I do see that there's some questions, and if you have any other questions, we can take those. So I'll pass it over to Rachel.
Perfect. So we have one question here in regards to shuttle mediation, and if you're able to just explain what that is.
Yeah. So basically, from my understanding, what that is kind of what I was describing earlier, where, um, well, most mediations, I'll speak for myself, I try and start them together. But a shuttle mediation is where you put the parties in separate rooms and then the mediator transfer information between one party to the other. This is it is a normal process in mediation. It is people need to have private time to speak to their lawyers. They also need to, if they don't have a lawyer, like, you may not, there might be other people that you want to talk to in confidence and get some opinions on before you do any counter proposals. So the mediation process, what I'll say is usually it starts off with like introductions and people getting like, the mediator will introduce a process. The mediator will go through an agreement that says, in summary here, what happens at the mediation stays at the mediation. It's a without prejudice conversation. So that process usually happens together in the same room. And then the mediator will say, the mediator, before you go into the room of the mediation that day, will have had a private meeting with each of you before that mediation started. And actually, this is great. I forgot to talk about the screening for domestic violence. So I'm going to do that now. So in that pre-meeting, for mediation, there's two purposes to that from a mediator's perspective. One, they're trying to get to know you and your issues and figure out why certain things are important to you and what are some of the things that you're willing to move on and what you want. So that's one purpose. The other thing the mediator is doing is they're also screening for gender-based violence and to see if the process itself is going to be a safe process for you and for the other party. If the reasons for separation and divorce is, I'll use the word domestic violence, and there's, for example, no contact orders in place, then you cannot likely be in the same room together. And so then there have recently been mediations where people are in separate rooms and the agreement is the mediator will go between rooms. So shuttle mediation in plain and simple language is when the mediator goes from one room to the other and is transferring the information. If you are going through a process of shuttle mediation, it is very important to be clear with the mediator what information it can be shared, what information can't be shared. Because sometimes in a mediation, I have been told certain pieces of information and I have to say to the client, now, it depends on what's written in that agreement. There is mediations where the mediator will say, I'm sharing everything you say to me to the other side, vice versa. Or the mediator, you can say, I'm telling you this. The reason I want this is because of, this reason, but this reason is confidential. So I do not give you permission to share this with the other side. That's the one thing you want to be mindful of in shuttle mediations is what information is going to be transferred and can some of it be confidential. So that's important. But I do want to go back to mediation. That mediators need to screen for power imbalances. They need to screen for gender-based violence. They need to screen for where there is emotional and or financial abuse. And the process will not be fair in those scenarios if everyone's in the same room. And it might actually not even be an option. Mediation just might not be an option if some of those issues are prevalent. Especially if there's not another lawyer there for the person maybe who is a victim of some of that. So that's an assessment that the mediators have to make. And they always have to screen for family violence and make sure it's a safe environment before it goes forward. Yeah. So
Okay.
yeah, shuttle mediation isn't anything different. It's just a process in the mediation where the parties are in separate rooms and the mediator travels from one room to the next.
Perfect. Okay, the next question is there a waiver of not seeking independent legal advice and understanding the nature and consequences of that? And is that accepted? So I think,
Yeah, there is a waiver for not, yeah. So you can definitely always sign off on, you can say, I waive my right to independent legal advice. But I would encourage people to be very careful when you do that. Make sure you understand what you're signing off. You can definitely waive independent legal advice. It should have always be offered though. And so the important part is to make sure it's being offered. And if the other side is saying, no, I know exactly what I was doing. I'm fine with this. This is what I wanted. Maybe they got legal advice before they came to the mediation. And now the agreement has come out the way they were anticipating it to. They always have a right to say, no, I waive my right. But I can say that as a lawyer and as a mediator, I would always encourage having independent legal advice and a waiver signed, like having a lawyer witness that signature. Because if there's ever any disagreement about the agreement being unfair or a party claiming they didn't understand something, you have something to fall back on. There was independent legal advice provided.
Okay. The last question we have here is power imbalance. Try to negotiate? Question mark. So, um, is that something to try to negotiate when there's a power imbalance? I'm
Mm,
assuming this is like between the two parties.
yeah, so I mean, you can't really negotiate a power imbalance because that's the dynamic of that relationship. And we see a lot of that. So when we look at what I'll quote unquote call traditional relationships, where one party is working outside the home and the other one is perhaps in the home raising the children, there's usually some sort of dynamic and power imbalance there. And there's also a financial imbalance. That scenario alone doesn't mean that these things exist there, but that is one of the situations where I've seen it. Um, Usually, power imbalance also involves one party being incredibly isolated and not connected to the community in other ways. And then also with power imbalance, unfortunately, finances is huge. And so access to resources. And I don't know how many of you are self-representatives because you're like there are some people that have access to money and they are going to lawyer up right away. And guess what? They are going to bring application after application. And that in itself is also a power imbalance. And there's been a recent report from the Rise Community Legal Clinic, Women's Legal Clinic, that talks about power imbalances in family law and how repeated court applications and litigation it is a tool that is used as a form of violence in a way against women going through the court process. So that can be an example of power imbalance, just access to resources. Because especially if someone's been working out of the home, they've been able to, they're the income earners, and then the person inside isn't, or maybe they're new to this country, they don't know the system. Now they don't have any funds, or maybe they've got assets tied to their name and they won't qualify for legal aid. And not everyone speaks a language and not everyone writes English and or French, we can say, and our court systems are designed to hear those two languages. And yes, you can get interpreters in court, but filing those forms is much harder when you don't know how to read them and write them out. So that's a formative example of power imbalance, but you can't really negotiate power imbalance. I think it's something that's it's ingrained into that relationship. What mediators can do is try to make sure that decisions are balanced in the mediation and that a power imbalance, and mediators, this is their job, is to make sure that imbalance is not reinforced in that mediation and is not a reason for that mediation agreement.
Okay. There's a question about hearings, but I'll answer that one. How do you select a date for a Supreme Court hearing when self-represented? So there is the Supreme Court scheduling department that is available for each court location. And you can contact them. Either they have the dates available on the website or you can call the Supreme Court scheduling department and they can provide you with the availability for the hearing that you're looking for.
And they update
Um,
that list every day. So if you are looking, you can always check the list in the morning, but then you always need to call because sometimes those dates go really quickly.
they do, yeah. So definitely give the scheduling department a call for the registry that you're looking for. Okay. Is there any other questions that you guys want to submit?
I see a question that I think was sent to me.
Oh, okay.
I'm not
Yeah.
sure if I totally understand it. Gray divorce? Do you
I
talk?
don't I don't see the question directly to you, unfortunately.
Okay, the question is, do you talk about gray divorce at all in the next sessions? So maybe that means divorce when you're senior.
I'm actually not familiar with that
I'm
terminology,
not
to be
familiar with it
honest.
either. So yeah, okay.
Yeah.
It is seniors when their seniors are divorcing. I
Okay.
don't
Well,
know, Rachel, if there's a special section on that because the issues would kind of it's usually assets when divorce is happening at that age, assets and pensions. So I would say if there's
yeah.
any sessions in this course around asset division and pension division, that would be really, really important.
Mm-hmm.
Especially I didn't know it was called gray divorce either. I've referred to it more as seniors divorce. But yeah, so it's kind of nice to know that that's what it's called on the streets, I guess. But
Yeah.
yeah, so because usually there's assets involved and pensions is the big one. Um, and how that like works and then RIFs and RSPs and all those things.
Yeah. I mean, we don't have anything specific for great divorce in this program. We're more of general. So we don't necessarily get into the nitty-gritty bits of that, but the person can certainly send an email to our info@litigantbc .com. And if it's something that we can answer, we can certainly get back to them. I don't see anything else in the chat. Did you have any other direct messages or was it just that one?
Nothing really. I just want to just encourage thank you for everyone for being here today.
Yes,
I just
thank
want to
you.
really encourage you to think about settling some of the things that you can agree on. And even if you are going to go to a trial, oh yeah, so if you are going to go to a trial, you don't have to go for everything. If you've made agreements on certain things, you can let the court know. We have agreed on our parenting time. We've agreed on our child support. And the only reason we're here today is asset division or whatever it is. So you can really narrow down the issues. And if when you narrow down the issues like that, you can narrow down the court's time and you can narrow down your expenses as well. And so that is why if you can negotiate some parts beforehand before going to trial. A lot of times people don't realize that. Um, and so yeah, just encourage you all to keep considering settlement options. It gives you some control. It will give you some peace of mind to get some finality, especially if you're looking at trial dates that are 2, 3 years down the line. Even if you set those trial dates now, maybe in a year's time, you should go to a mediation. So thank you.
Thank you very much, Mina, for joining us tonight. And thank you, everybody, for attending. We will see you guys next week on Tuesday, November 21st. Thank you so much.
Yeah, enjoy the rest of your sessions.
Thank you.